I'm going to take a different view. Um, Obviously, not that. I mean, whether I believe in it or not is a different issue, but it's something that worries me constantly about this practice of mitigation investigations that we do. The effort to get the Supreme Court to recognize that, even though it's said, as Professor Rao was saying in Bachchan Singh, it's nearly 45 years ago said that, oh, you need to do the rarest of the rare. It's only much later that the court really gets to pay attention to how is this information to be collected. And obviously there's a strategy that was 6 or 7 years in the making, through our cases, that led to the Supreme Court in Manoj saying what it did and saying that the defense has a right to present a mitigation investigation report, right? So that's what we do as a defense. We are presenting it as part of the defense. And the court is also calling reports, what it calls independent reports from the jail and the independent psychiatrist, right? So this judgment in Manoj is a 6 7 year long strategy finally coming to fruition in 2021 2022, right? And of course it's a interdisciplinary exercise. It's something that Maitreya and I have written about, the challenges of the interdisciplinary nature of this exercise. It's not something that just lawyers can go and interview and just write up, right? So it's a very complicated exercise, right? And I'm going to be arguing today that there are serious concerns that a mitigation investigation process is a dignity harming experience, right? And why do I say that? We need to understand that a mitigation investigation is essentially an exercise against the clock, right? It's against the clock because the Supreme Court gives you a set number of weeks to go and do this and file a mitigation investigation report, right? And I mean, these are far-flung prisons. The prisons have their own way of how they facilitate this or don't facilitate this and how the barriers they put in place. And the biggest challenge in this exercise is going and gaining the confidence of these individuals, the convicts, in getting them to open up, right? Getting them to speak, because for the longest time, prisoners will want to present very good versions of themselves, right? Or of their families. But what is of tremendous significance in this process is to hear about the worst parts of their life, right? And that's what you need to get to. That's what you need to get people to open up about, right? And you are against a clock. The Supreme Court gives you 8 weeks or 12 weeks or whatever it is, and in that time you have to gain the confidence and you have to get them to open up and start probing into really dark, disturbing parts of their lives, of their childhood, of their adolescence, of how they were as young adults, if they're married, their married life, their sexual life, domestic abuse, all of those things, right? And in that, and I'm going to be saying that they, the amount of time we are able to give to genuinely convince them and make them understand why they are doing this, right, is often restricted, right? You're fast forwarding that process because you need to get to the stage of collecting that information, right? Or getting that information, right? And I'm going to, my core of my argument is that the the system's commitment to having the death penalty and then presenting this mitigation investigation as somehow an exercise in dignity, because you are then saying, I'm doing, the law is recognizing the need for this mitigation investigation because it's saying I need to make the sentencing process fair and individualize it. So I am asking you, I'm recognizing it as a right, that it, as part of the process of making it fairer, of making sentencing fairer, if you want me to really hear about your life story, present this mitigation investigation to me, right? And therefore, confronting the death row prisoner with the choice that if you want your punishment reduced, if you want a shot at your punishment reduced, you have to go through this process. And I think very often this and that presenting of the stakes like that, if you want your punishment reduced, this is what you have to go through, is what then the mitigation investigator is relying on, that they will get the prisoner to open up or at least understand that instrumentally, even though they don't genuinely may or may not want, and there's no way to figure this out, is the problem of this. There is no way you will know whether they genuinely want to have that conversation with you. And that conversation is being had with you for a very, very instrumental reason. And you, as a mitigation investigator who is part of the defense team, is having that because you are playing for it as a matter of strategy. You're playing for it as a matter of criminal defense. You are not playing that strategy as a matter of well-being or for therapeutic reasons, right? You're not doing that. You know that. You're hoping that the other person knows it. But as you get deeper and deeper, and as you go into these aspects, I think often prisoners are forced, not forced, and that's a point. We don't know what their own thinking on is going through these dark, shameful experiences that they have to narrate to more or less an effective stranger within 6 weeks of time, right? And that and you don't really have a control over the kind of questions that are being put to you, right? The mitigation investigator is coming and telling you that that person is a part of the defense team, is part of your defense team, and if you want to reduce your punishment, you might want to seriously consider starting to answer these questions and start answering them pretty quickly, right? And of course, it's a very fascinating, complicated dynamic as to, how do you know people are not really telling you the truth? How do you know they're not telling you the full truth? How do you, at what point do you introduce contradictions in what they are saying compared to what their family has already told you, right? At what point do you play these strategies in towards getting genuine information that can be presented towards court? So one is, you don't really have, I would think, you don't really have a choice in participating in what are deeply vulnerable conversations, right? And two, you don't have a control over what questions get asked. And thirdly, once this information is collected, right, from the prisoner, from their families, from their acquaintances, from their workplaces, some exercises of this nature will finish probably in 50 hours of interviewing. Some will go on for 400 hours of interviewing. It really depends on a whole host of factors. What you don't control then either is your own story that will be told to the court. So there is one process of collecting all this information, and then there is weaving a narrative about this person that then needs to be presented in court. And of course, senior lawyers who appear for us, they are the biggest hurdle. I shouldn't be uncharitable towards them. They've been extremely helpful in appearing for us pro bono over the years. But there's also reluctance saying, "Arey, why do we want to present all this Rona Dhona in front of the court?" Right? And that's a limitation of the legal practitioner to imagine these interdisciplinary ideas of criminal responsibility and culpability and all of. But anyway, the point is, this collection of information then is strongly mediated by court strategy. And the prisoner themselves, the convict themselves, has no real control over what story of theirs is being woven in front of the court. Right? Yes, you have the information. What points of that information you emphasize, how you present it, what you emphasize, what you de-emphasize are all matters of legal strategy. Right? They are not matters of genuinely telling a story that that person wants you to tell about them in front of 3 Supreme Court judges, right? It is not some sort of pure translation of their story in front of the court, right? So even in that story that gets told about them, they don't really have any control, right? And then I think we are often left feeling, and I agree with Maitrey to that extent, that the narrative of being heard, that their experience of being heard is that repeatedly comes through many of these mitigation investigations. That the number of times we hear that finally I could tell somebody my story is a sentiment that keeps coming through repeatedly. But for me, that is a danger. Because I think very often all of us at work are left wondering if then beyond a point, as you get deeper and deeper into these conversations, there is an emotional dependence that develops, right? That here is this person who's coming day in and day out and coming and talking to you. You know, it's the conversation is being had about your life in a way that nobody ever perhaps has had that conversation, and that dependence. Whereas you, as a mitigation investigator, know you are doing this only for purpose of legal strategy, and the day this is over, you are done. Right? You are done. You are not going to look back, and you have opened certain doors. You have opened certain wounds. You have revisited certain wounds of this person's life in great depth. You have left them confronting questions that they haven't heard articulated to them. You are more or less forcing them to articulate their response to this, right? And very often we hear that, you know, when they go back the next day, they say, okay, you know what, I really was left wondering about all that you asked and all that I said. And it is a deeply disturbing situation to be in when you know you have open doors you cannot shut, right? You cannot shut it because your job is not to provide that therapeutic process. Your job is to collect that information, strategize it, and put it in front of the court. But by the time you finished your 40 or 50 or 100 hours of interviewing, where have you left that person? Right? And some of you who do the clinic, some of the materials that we will hopefully supply by Monday morning, right? Uh, you will see, you will see the kind of conversations that are being had, right? And for me, that it raises serious concerns of dignity harms because as I said, it's you're not really sure why they are having this conversation with you, how much of it is forced, how much of it is voluntary, how much of it have they understood that this is for their own good. But even if they understand it is for their own good, the system beyond a point is forcing you to have that conversation because that is the method that the system has devised for you to even stand a shot at your punishment being reduced from a death sentence to life imprisonment, right? So in that even you are forced to instrumentalize your own participation, right? In this process, you are forced to participate in that sense, saying, okay, this is the only way you're going to get a reduced punishment, right? So while I have absolutely no doubt that the legal strategy that we played out in the lead up to Manoj has certainly made this administration of death penalty sentencing fairer. It has further individualized it. I think there is a other side to this coin, right? That we have just accepted as collateral risk, right? That we said in a deeply flawed system, this is your best shot at reducing the number of times the Supreme Court confirms the death sentence. And yes, we're extremely proud about how how few death sentences. I mean, I just want to, as the court is about to reopen in about a week, I just want to be touch wood, how few death sentences the Supreme Court has been confirming. No death sentence confirmation in the last 2 years, right? It takes a lot of strategizing to get to these places, right? But I often wonder what the human cost of that has been. Thank you.